picking the next Supreme Court justice, and this is an issue of the utmost importance. And historically, this hasn't been an issue that registered in presidential elections, but it should. On Inauguration Day, we'll have 3 justices over the age of 80 and 1 who will be 79. And if you fast forward for 8 years hence, you'll basically have 3 judges on the steps of 90. And that historically has been the upper limits at which a justice can serve. So the next president very likely may appoint 1, 2, and conceivably 4 justices. And this will have the effect of shaping not just the court, but indeed the direction of the law for a very, very, very long time. So it's a very significant issue, and it's one I am dedicating considerable amounts of time to raise awareness of and have people think about. I'm immediately after class tonight, as I try and watch the debate on the way home. Yeah, not happy about that, but we will endure. I'm more interested than Trump, Dory. You'll get a lot more entertainment here. But tomorrow, actually, I'm doing a debate on appointing justices in Atlanta. So I'll be on a plane first thing tomorrow morning. But this is an issue that, and there'll be a video if you want to watch. But it's an issue of significant gravity that people do not pay attention to nearly enough. But I appreciate the acknowledgement, Mark. Okay. Other questions? Anything in your mind? No? Okay, so today we are continuing our discussion of what can be broadly termed substantive due process. And this is the notion that the Due Process Clause, which has a protection of liberty, doesn't merely protect procedural rights. And last week I gave the example, or last class I gave the example of the lottery, right? Imagine a circumstance where you have a trial that's inherently fair, every procedure is scrupulously adhered to, but at the end of the day, a woman is stoned for doing absolutely nothing but drawing a lot that had a piece of that had a mark of coal on it. And this is the sort of discussion that we have to consider, because once courts intervene and courts decide not just whether a law is procedurally fair, but whether it's substantively fair, that offers a significant ground for the justices and the judges to inject their own personal views on law, on life, and philosophy into the courts. And this is often a very controversial element. So the first glimpse we had in this country of this notion of substantive due process, we mentioned, came the Dred Scott decision. But the biggie came around the turn of the century and into the early 20th century with a line of cases which are often incorrectly called the Lochner era. This is not an actual era, it never actually happened, but it's often referred to as a series of cases where the court was very aggressive in enforcing what was called liberty of contract, the idea that the state cannot violate a person's economic rights without a good reason. And what's difficult to understand about these cases is at the time, these were viewed as horrible. Why were they horrible? Because they interfered with the progressive state. And much of the progress of President Franklin Roosevelt and others was to reject this line of thinking and say, you know what, we need to have experts, we need to have boards, we need to have various grounds on which the state can help people and protect safety, and protect workers. And if we have these old white men in the Supreme Court, that's what they're called, the 9 old white men, doing these sorts of things, then we can't promote progress. So the project of the late 30s, 40s, and 50s was to get rid of substantive due process and get rid of this idea that there's certain liberty interests protected by the Constitution. The problem, though, became what happens after you get past economic liberty. And you have other sorts of liberty interests that liberals and progressives tend to like. And I'm talking about birth control and abortion. And the inherent tension, which last class finished with, and today's class will also conclude with, is how do you reconcile having courts decide reasonableness of legislation with respect to contraceptive and abortion, but not certain types of economic regulations? And the standard answer is, well, you know, reproductive rights are fundamental and economic rights are not. Says who? Right? Arbitrarily labeling a right fundamental doesn't get you anywhere. It doesn't carry any water. So our cases today begin shortly after the Lochner decision in 1923. It's about 15 years after Lochner, with a decision called Meyer v. Nebraska. There was another case antecedent to that, before that, court called Pierce v. Society of Sisters. And these cases were decided against the specific backdrop, the specific notion that the 14th Amendment protected certain liberty interests that the state could not violate. These were direct lineages of Lochner. And no matter what the Griswold court says, they were. And to accept Myers and Pierce, but to reject Lochner is awfully difficult because they were based on the same sort of judicial philosophy. In fact, the same justices who would write Lochner would go on to write the same sorts of things in Meyer and Pierce. Any questions before we start? Unfortunately, a book doesn't give Meyer any details. You have a question? Or are you asking for the role? I have a question. So I only started recently doing attendance about a year ago, and I hate it. I hate the people waiting for it to pass across the room. Would you prefer if I just leave it at the front, you could sign at the beginning or sign at the end? Would you prefer that? You rather pass it around? Yeah. Really?
Otherwise, we wait online like it's red line.
If you start with the same person,
Yeah, there's a pattern. Okay, I always try and side with whoever's here, at the corners. All right, well, I'll leave it as is. I hate taking attendance because it's a waste of time. They make me. I don't like doing it, but I have to. But if this is what you prefer, I will oblige. So your book doesn't give Meyer v. Nebraska in any sort of length, but I'll give you the background of the case. Nebraska passed a law prohibiting the teaching of any foreign languages. Okay, this case was 1923. Anybody want to take a guess what language they were talking about in 1923? No, it was not Spanish. No, German. German, yeah, right? This is a couple years after the First World War. The Great War, as was called then. It wasn't called World War I because we didn't have two yet. So a couple years after the Great War, Germany passed a law banning the teaching of foreign languages. This was a nationalist law that was meant to basically exclude any sort of foreign education. You probably know this, but there was serious anti-German animus during World War I. They renamed sauerkraut liberty cabbage. I have a dachshund at home. They actually would beat up dachshunds because they're considered German dogs. So it's considered like there's a lot of anti-German stuff. People, the dogs they get upset, right? You know, yeah.
I have an Alsatian.
What was that?
I have an Alsatian.
Okay.
German Shepherds. The British were.
There you go. Right. So this law was passed that said you can't teach a foreign language. Okay. Is there any constitutional difficulty with this law? So a lawsuit was brought challenging this law. And the court held that one of the liberty interests of the Due Process Clause is the right to engage in a lawful occupation, the right to acquire useful knowledge, right? The right to establish and bring your children up as you wish, okay? The majority opinion by Justice McReynolds listed a whole host of liberty interests that the Due Process Clause protects. And for the state to flat out prohibit the teaching of a foreign language is effectively like prohibiting people working from too many hours. You don't have a good reason to do it. You have the right to choose what language you want to teach. If it's a lawful occupation, you can do so. Dissenting in Myers was, of course, our favorite Justice Holmes. And Justice Holmes, much like he said in Lochner, said, I'm not prepared to say this is unreasonable, right? It's not the place for the court to intervene here. Now, if I told you the state passed a law approving this, the teaching of German, let's start. Where did I finish up last time? Aaron, before we did due process, right? If I told you the state passed a law approving the teaching of German in schools or wherever else, which provision of the Constitution would you think that offended? Which provision would you probably sue on? You can't teach and you can't, engage in instruction in German language. So let's say them for help.
I'm thinking to where it's the any power.
You're thinking way too hard.
I'm thinking way too hard.
Yeah. Which is a really easy one? It's first.
First Amendment,
Yeah. Why the First Amendment?
because it gives you the right to free speech.
Yeah. So you would think, right? Wouldn't this be a First Amendment case? You can't speak German. You can't teach German. Aaron, why could they not have brought the suit under the First Amendment in 1923?
Because at that point they really had not made any decisions on the First Amendment.
More specifically, at that point, where did the First Amendment apply? I've mentioned this a few times. Who was bound by the Bill of Rights in 1923? Which branch of government? It's in the first word of the First Amendment. No. Johnny? Originally, who was bound by the first 8 amendments to the Constitution? Which branch of government?
Oh,
What?
Congress.
Congress, yes, the first word of the First Amendment, right?
And call it.
You can always cheat, right?
Yeah.
The Supreme Court had not yet even held that the First Amendment applies to the states. This was a fairly novel idea that the Bill of Rights limits the states. So instead of having the Bill of Rights be limited, they looked to the Due Process Clause. Why? The Due Process Clause specifically protects state infringement of rights. And Justice McReynolds reads into the Bill of Rights a whole host of liberty interests. Okay? So that was 1923, Meyer v. Nebraska. 1925, Pierce v. Society of Sisters raised a similar issue. So Johnny, what were the facts in that case? Oh, was that going this way? This is which I was going. Okay, yeah, Johnny, what was that? So what were the facts in this case?
Was the Hill Military Academy.
Mark's laughing too hard. No, I think you're up. Yeah, go for it.
Basically, the Oregon had a compulsory education law.
No, it wasn't just compulsory education. What did it do?
Well, required that children go to public schools.
Public school, okay? So you recall when we did the civil rights cases before, that until the 20th century, most states did not have compulsory education laws. That was a fairly new idea. But Oregon tried to do something different. They said not only were you required to go to school, you were required to go to a public school. Now, John, why do you think the state enacted this law?
Probably in an effort to shut down the private schools.
What kind of private schools were they trying to shut down, Johnny? Who were the plaintiffs in this case?
Religious, like the Society of Sisters.
What are the Society of Sisters?
What they lead a group of Catholic Church.
It's an order of nuns. Okay. Let me give you some background. This is something you don't hear about very often. In the 20th century, there was significant anti-Catholic bias. Significant. You'll see there's this great cartoon by Thomas Nast about the Pope with this kind of alligator-sized head, the Pope hat, right, coming and taking over America. Indeed, when John Kennedy was elected, there was fear that he was a papist. He was loyal to the Pope, and they'd be like a Manchurian candidate for the Pope in Washington. The womanizer was not so much, but there was this legitimate fear. Many states viewed Catholics as evil. And has anyone heard of the Blaine Amendment? You know what that is? Most states have them. It basically prohibits states spending money on public schools. I'm sorry, states spending money on religious schools, right? You say, wow, that's great, separation of church and state. No. The Blaine Amendments were passed after a senator from Maine named Blaine, who hated Catholics, and he wanted to make sure that states did not fund Catholic schools. Taking this one step further, by saying your kid had to go to a public school, you're putting out of business all of the religious institutions, all the religious schools. And indeed, that's what happened. After this new ordinance was announced, parents start pulling their kids out of the public school, out of the schools, because the parents would actually be fined. Okay. All right, Johnny, right? So Amanda, who brought suit in this case? What was the name of the group? Who is a named party in this case? Okay. Is the Society of Sisters a person? It's a corporation. Imagine that. I make this point all the time, but the notion that the corporations do not have constitutional rights is farcical because it goes back to 1920. This is not Citizens United didn't create anything. So all the outlash about the case just boggles my mind because it requires a serious ignorance of history. But anyway, so a corporation asserted a constitutional right. Whose right was this that they were asserting, Amanda? Whose rights are being infringed here? Yes. So not only was a corporation asserting a right, it was asserting a right on behalf of the parents who would send their kids to this school. Imagine that, a corporation, a group of people asserting rights among others. Another recent example, in the Craig v. Boren case, one of the plaintiffs was actually the owner of a bar because the owner of the bar wanted to serve, the owner of a convenience store wanted to serve alcohol to men and he couldn't. So yes, corporations do preserve rights of other people. So don't fall into that trap. It's too easy. Okay, so the Society of Sisters brought suit, trying to vindicate the rights of parents who are no longer able to send their children to this school. Now, let's say, Renee, if I just told you the facts of this case, right? Which clause of the Constitution do you think the plaintiffs would rely on? You know, making it hard to go to religious universities, right? Which clause of the Constitution would they rely on here, you think? What's that clause called? Take it out. Take your Constitution. Go for it. It's on the first page. Which right? No. I'm glad that's wrong. This is not an issue of establishment. Which clause of the Constitution is implicated here? Keep reading. Read the First Amendment, please. Just read it.
Congress shall make no law respecting the establishment of religion, prohibiting the free exercise thereof.
Stop. What does it mean prohibiting the free exercise thereof? What does that mean? We'll do religion later, but what does that mean? You're mumbling. I don't know what you're saying.
Can you ask me again?
What does it mean to prohibit the free exercise of religion? What does that mean?
Oh, that you're prohibiting the right to choose, what faith.
Not just what, but how. Right? Not just which faith to choose, but how to go about practicing it, how to exercise their religious beliefs. So you would think, right, that these sorts of cases we brought on the free exercise clause. But again, in 1920, 1925, whatever year this was, they frankly did not have any case law governing the free exercise clause. That was a new ground. So instead, Gina, I'll skip over you. I'll come back to you later, okay? You sure?
Yeah, go for it.
Okay. So the nuns brought suit under the Due Process Clause of the 14th Amendment. Okay? And Ginny, what did they allege? What did the Society of Sisters allege was being violated? What right were they saying was being violated?
The liberty interest of the parents to decide their children's education.
Exactly right. Look at that off the bat. Very good. They brought suit under the Due Process Clause, right? And they said, okay, look, the word liberty is there. You're violating our liberty interest. What is this liberty interest? The right of parents to choose how their kids are educated. All right, now, Jenny, here comes a harder question, right?
Okay.
Where do you get that from with the word liberty? Where do you get that from?
It's actually nowhere specifically written in the Constitution or Bill of Rights. You get it through the numeral rights.
What rights? Penumbral?
Penumbral.
Don't say that word yet. We're not there.
Okay, sorry.
No, that comes later. But how does the Pierce Court understand what rights go with this phrase liberty? How do they know that the right of parents to direct the education of their kids is a liberty interest protected by the 14th Amendment? Where do they get this from?
Well, the court says it's a fundamental theory of liberty.
I know they say it's a fundamental theory of liberty. Where do they get that from? Yeah.
Yeah, okay.
Andrew, want to take a stab? Where do they? I mean, the opinion's short. It's not very long. I'm sorry.
I was looking at the same thing she was, the fundamental.
What does it mean to call something fundamental?
Um,
Does that mean anything? What's that mean, fundamental?
well, something that's required
Where do we get this from?
or natural born rights.
How do you know what those are?
Because it's stated in the Constitution.
Where in the Constitution say the right to education of children? Point of clause.
Well, I don't know. That's not stated in there. but
No,
the
it ain't.
liberty
Michelle?
part is. What?
You're like that guy in Jeopardy. What? Right. So where do we get this right from? How does Justice McReynolds? He says it's fundamental. He says all this stuff. Janine and Enter exactly right. Where do you get this from?
I don't think he got it from anywhere. I think it's made up. I think this was a way for them to pull out of the 14th Amendment of what they were defining what liberties were. And they were pulling out of law terms, I think. I think that's what they created, the economic liberty out of that same amendment. And I think that's what was going on here. They were now adding to what liberty meant.
Roy, was your hand up?
Yeah, I thought he used Myers v. Nebraska.
Right, and that was he also wrote.
Okay. Well, yeah.
Yeah, I
Well, he
mean,
refers back to that and uses the same rationale.
yeah, and you didn't read Myers, but it's the same kind of deal. By the way, when a justice cites another opinion by the justice, that doesn't answer my question, right? You have this fetish of saying, oh, well, this case, it is. Well, that case may have also been wrong. So here's the rub, and this is why Lochnerism was considered so controversial, because there's nothing in the Constitution that says what a liberty interest is, right? There's nothing in the Constitution that says you have the right to bring the child of your choice or direct his education. There's nothing that says the right to teach whatever language you want. There's frankly nothing in there. What's going on here is, of course, that this law is stupid, right? This law is unfair. This law is unreasonable, right? If people want to send their kids to a Catholic school, why shouldn't they be able to? If people want to teach their kids German or Swahili or whatever, they can teach them that language. Invariably, what this encounters is when the state imposes on a person's choices, on a person's autonomy. Substantive due process allows a court to step and say, wait a minute, that's not reasonable. That's not fair. They can dress it up with whatever language they want. Fundamental, deeply rooted, whatever adjectives you want. There's actually a footnote by Learned Hand in the Griswold opinion that discusses this, right? Give it whatever adjective you want. But at bottom, a court is deciding this law is simply unfair. This law goes too far. This law is not right. And what infuriated some of the New Dealers was that this interfered with various aspects of progressive legislation. Throwing kids in public school, Common Core stuff, right? I mean, this is basically a preview. But the court on this issue is basically unanimous. Now, let's put aside the Constitution for a second. Cameron, forget about the Constitution for a second, not for long, but for a second. If I were to tell you in the year 2015, Texas passes a law that prohibits kids going to a private school, what do you think would happen to that sort of law? Why? Right. The general idea is people want to do what they want. People don't like to be told what to do. This is inherent in virtually every aspect of law. People like to do what they want. They want to take birth control. They want to go to a public school or a private school. They want to teach German, whatever. When the state says, no, you cannot do this, people will get angry. And at bottom, the court's decision was effectively saying the state does not have a good enough reason to piss people off. Even though this law went through the democratic process, even though this law was enacted by the legislature, that is not good enough for the court. Now, another point, just to respond a little bit to Michelle's idea, it's not entirely true this was meant to have whole cloth. And this is a point I tried to make about the Lochner decision. There was a history of liberty of contract in the 14th Amendment. The idea that the state cannot put unreasonable restraints on your labor, on your working. And indeed, going back to the beginning of time, parents had authority over their children. And historically, parents had a very important role in deciding how their children were raised. I mean, today in the ages of child services and everything else, that's not as much true. But historically, parents raise their kids, and if the parents were bad parents, then sucks for the kid, right? So there was actually a tradition of parents being able to raise their children going back very far. So Roy, let me ask you this question. What happens if there is indeed a tradition going back very far, and this is a tradition that a lot of people recognize as being very important? Should that at least guide or shape how a court interprets this doctrine in this case?
My gut's telling me yes.
Why is your gut telling you yes?
Well, if there was a problem with it, the court would have already.
Not the court. If there's a problem, then who would have done something
The
about it?
state.
Exactly, right? If there is indeed a tradition that's been going on for so long, if it was so problematic, it would have been changed, right? This is why the common law has such importance. These are doctrines that developed over hundreds of years by slow iteration, slowly refining it to get to where people want it to be. And in many respects, courts honor the traditions. So when Justice McReynolds lists these rights about, parents raising their children and marriage and these sorts of things, he wasn't necessarily making up that whole cloth. He was using his best to identify certain principles, fundamental principles that are deeply rooted in our society's traditions, right? So this is not some sort of freewheeling make it up as you go along, although people would accuse him of doing that. He was trying to ascertain, what are these traditions that have been around for a long time? They're not complying with that now with this new law. This is an unprecedented law. Let the court step in to stop it. So there are varying degrees of attack of substantive due process, depending how cynical you want to be. But McReynolds wasn't basing everything. So for example, in Myers v. Nebraska, the first case, he said, I'm going to read this to you. What are these rights? He says, the right of the individual to contract, to engage in the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of his conscience, and generally to enjoy these privileges long recognized a common law as essential to the orderly pursuit of happiness by free men. What he's trying to do there is say, what are these really important rights that have been around for a very long time that we respect? Is there a consensus on these sorts of rights? If the answer is yes, well, in that case, then courts can step in when a legislature tries to infringe on those. So it's not making stuff up. If we want to get to making stuff up, we get to the penumbras, which Janine jumped the gun on before. That's making stuff up. But here, he's actually trying to ground this in some sort of historical notion. Yes, Michelle?
So is the court there acknowledging the majority over the minority?
Hanzo's not here. What do you mean?
Well, we were talking about something that has been done over time. A great deal of people tend to follow this. So again, is that majority over minority?
Well, let me ask you this, the preview of Bergefell. They mentioned marriage there. What kind of marriage are they talking about? Not Myers.
Oh, no, I'm sorry. Oh, no, I apologize. No, they're talking about a man and a woman.
And effectively, another case from the same time, they say marriage, which is essential to our existence, or essential to our survival.
Procreation.
Why is marriage essential to survival? Procreation. For the human race to continue, you have to reproduce, right? Birds and the bees. So, yes, it's a very backward-looking approach. Only those rights which have been around enough for the democratic process to recognize them. This approach is not necessarily consistent with new rights. The penumbras, though, that is a little bit more open-ended. We'll get to Griswold later in class. All right, other questions on Pierce?
I had a quick historical question.
Yes, sir.
Was this the co-appellees military academy? Were they just collateral damage by the state? I mean, by trying to
Yeah. Yeah, I mean, they were mostly looking after Catholic schools, but this is actually the Hill Military Academy, which was a private school in Oregon, but they were mostly looking after the churches. And they couldn't pass law straight up saying that you could not have a Catholic school. They just made it brought up no private schools. This was mostly against the Catholic churches. By the way, there's also Catholic orphanages and other Catholic institutions. It wasn't just a school. This is an anti-Catholic bill in very strong terms. All right, any other cases or questions on Pierce or Myers? So again, Pierce and Myers fit into the Lochner framework very clearly. It was the exact same sort of liberty of contract that was referenced. And it's fascinating to look at later the contortions that the Griswold course had jumped through to explain how they like Pierce and Myers, but they don't like Lochner. It's frankly disingenuous, but I'll be charitable. All right, so the next case, and I'll give a disclaimer. I can usually teach cases objectively with a few exceptions. One of which is Obamacare, which I think I made the same warning. Another which is I can as Kelo. It's wrong. This is the other case. I can't do Buck v. Bell objectively. I am actually utterly incapable of doing so. So if you want, read Justice Holmes' opinion, and he'll tell you why. But I'll give you my take on the case. So let's actually start with some of the facts of the case. This is actually Carrie Buck, who was the lead plaintiff. So why was she deemed feeble-minded? Okay, feeble-minded doesn't mean what you think it means. It doesn't mean mentally handicapped with a low IQ, or to use a phrase, retarded, right? That's not what this means. She was deemed feeble-minded because she had an illegitimate child. That is, a child where she wasn't married. She was charged with promiscuity. Do you know why she had an illegitimate child? She was raped by her uncle. So imagine that. Was that mentioned in the case? Of course not, because Justice Holmes couldn't care less. Here's a picture of Carrie Buck with her mother, Emma. Okay, I'll get to Buck's mom in a few minutes, but this is actually the doctor, Dr. Bell. He's the Buck v. Bell. He was a director of the superintendent of the hospital where she was sterilized. And this is actually the courthouse in Virginia where her case was heard, and I put that in quotes because it was not much of a hearing. This is the state colony for epileptics and feeble-minded. And again, these were people the state deemed undesirable. Now, this is the interesting part. So perhaps the most jarring sentence in Justice Holmes's opinion is a line about 3 generations of imbeciles are enough. And he doesn't explain what that means. You may think this is just some sort of rhetorical point of like, we don't need more, retarded people, right? It's actually a lot more gruesome. This is Carrie Buck's family tree. And I know you can't see it, but if you click onto the course website, you can go there. This says most immediate blood kin of Carrie Buck, showing illegitimacy and hereditary feeble-mindedness. Okay? This is what the doctor at the hospital did it. Now, you see here these little circles? This is Carrie Buck. This is Carrie Buck's mom. And this is Carrie Buck's daughter. See, there are 3 circles. Each circle has the letter F in it. F means feeble-minded. Feeble-minded grandmother, feeble-minded daughter, and feeble-minded granddaughter. Those are the 3 generations of imbeciles. They actually mapped this out, as jarring as it may seem. Why was Carrie Buck's mom feeble-minded? I think she had her out of wedlock or something like that, so she's deemed promiscuous. Why was the 1-year-old daughter of Carrie Buck deemed feeble-minded? This is actually the most disturbing thing. They went to the infant and they put a coin in front of her face. And they kind of spun it around. And they said, did the baby react to the coin? And the baby did not react to the coin. Therefore, she was feeble-minded. I wish I could make this stuff up, but I'm simply unable to. I have a picture of it. This is actually Carrie Buck's child. This is also Carrie Buck's child's report card, which we actually have thanks to archives. And she was actually a B student. Go figure. Flash a quarter in a child's face. Maybe they won't react because they're something. They're 1-year-old. I don't know. Again, I don't even try doing this case neutrally because I can't. So there you go. 3 generations of imbeciles are enough. And they actually mapped out, if you look at it closely, F is female-minded. You have these dashed lines about various venereal diseases people have. I mean, this is sort of this path for science. And you're saying, Josh, how the hell did this happen in the United States? I mean, you know, how could this happen? You know, this sounds like something out of Nazi Germany. And the answer to that, and actually Steve emailed me about this earlier, Americans invented eugenics. The Germans perfected it. And I can't make that point strongly enough. Indeed, Dr. Laughlin, right, that's the same doctor who had drawn up Carrie Buck's family tree, received an honorary degree in 1936 from the University of Heidelberg in Germany. And you can't read this, but it basically says, for his work in the science of, quote, racial cleansing. So the Third Reich awarded a degree to the doctor who designated Carrie Buck to be sterilized. Again, I can't make this up. I wouldn't even try to. Even worse, eugenics was not just viewed among scientists, but was viewed among elites as an important tool. So for all this BS of For Justice Holmes' dissent, talking about Mr. Herbert Spencer's social statics and social Darwinism, not even 10 years later, he upheld this case. For all I'm saying that, you know, we should not be social Darwinists, we should not subscribe to a single theory, he with relish upheld this case. He actually wrote that this opinion was easy for him. Presidents from Theodore Roosevelt to Howard Taft to Woodrow Wilson to Calvin Coolidge all favored eugenics. The presidents of Harvard, Yale, Stanford, every major academic institution favored eugenics. Helen Keller, God love her, right? The blind and deaf, the miracle worker, right? She favored eugenics to save other people from the same fate that she suffered from. I'll pause very briefly here to go back to Brown, and this is going to be a little jarring. But remember the footnote in Brown saying based on social science, we need to have, you know, integrated education? The same sort of social science in 1954 of education was quite different in 1925 with respect to eugenics. And Justice Holmes wrote against the backdrop of social science. So be very careful when you look at social science. So by 1937, 32 states had compulsory sterilization laws. These laws were not repealed in some cases in the 50s, 60s, and even the 70s. I had a student at some point, her parent was from Puerto Rico, and apparently Puerto Rico had this until like the 90s, where she told me the story, but teenage girls would go into these hospitals for like a tonsillectomy, and then while they were about to go into anesthesia, they would have them sign something. They didn't know what they're signing, and they walk out with their tubes cut. This happened. I mean, the girl's mom was, I don't know how old she was, but, you know, in the 80s or 70s, like fairly recently. It was only recently that Virginia and actually North Carolina made reparations payments to many of the women who are still alive and suffering from this. This is Carrie Buck years before she died. And here are some advertisements, propaganda, if I may. And that what this one says, we can't read it, says, some people are born to be a burden on the rest. Learn about heredity. You can help to correct these conditions. This one says, eugenics is a self-direction of human evolution. And there was this serious sense that through selective breeding, they could actually improve the human race. Oh, and here we get to Mr. Holmes. We were 3 generations of imbeciles enough. All right, anything else I want to show you? Yeah, I'll leave it on here so we can see Holmes. Again, I get no pretenses of objectivity on this case. So one other area I want to discuss is this law was passed in 1924. And I mentioned that year in Virginia before. Does anyone remember when I mentioned it? 1924, what law I was talking about? What? Exactly. The same law that prohibited miscegenation, interracial marriage, also created the regime by which Carrie Buck was sterilized. The link between racism and white supremacism and eugenics was tight, right? The same Virginia law that prohibited interracial marriage criminalizing it created the process through which Carrie Buck was sterilized. Yeah, and you know, you can just read through this. Oh, that's it. Buck's mother was feeble-minded, and the daughter was feeble-minded, promiscuous because she got raped, and then the granddaughter flipped a coin and she couldn't, so she was feeble-minded. Carrie Buck later in life said, quote, "They done me wrong. They done us all wrong." Indeed they did. Okay, back to normal. Whenever I call Holmes and BS in one sentence, you know I'm upset. But I'll try to be better for the rest of the class. Yeah, it's Obamacare, Kelo, and Buck. There's only cases I can't do objectively. Caleb has no broccoli today, which was a good move.
Celery.
I can do celery. Celery is okay. Yeah, Steve.
Also, did you mention the attorney?
I'm gonna get there in a few minutes. I didn't get to the facts of this one particular, but I will mention that in a moment. All right. Any other questions on what I just talked about? It's if you want to just, when you get a minute, scroll through these pictures. I put this up in the blog because they're jarring to see that this happened in America with you know, the elites of society, the presidents of universities, you know, the top scientists, which is why I don't think much of elites at any point in time. All right. Where was I up to? I think you're up next. All right. Jared, you want to walk into the facts of this case? By the way, the opinion itself is awfully short. There's a one note in the book that this opinion is the highest injustice to word ratio in the history of the Supreme Court. Because like in a few pages, Justice Holmes just went, you know, just throw it away. All right, Jared, go for it. What?
The Act of Virginia, 1924.
Yes, sir.
It was an act put into place by the state to sterilize people.
Right, and in case this wasn't obvious, the reason why they went to sterilize them was that they couldn't reproduce. They effectively wanted to eliminate these people from the gene pool, right? They actually view this as an act of benevolence. You know, these people are feeble-minded. They're going to grow up, have kids. Those kids are going to be feeble-minded, and it's going to be a drain, like a weight put on the state. Okay.
And then there's it was just a procedure.
Yeah, you want to walk us through the procedure, please?
Yeah.
Go for it. Yeah.
They had to present.
And by the way, as you read this procedure, I want you to think of the lottery and look at how fairly Justice Holmes describes this procedure. But go ahead. I'll interrupt you once or twice, but go for it.
They were to present to the board or other facts. The inmate was then given notice, and then a guardian.
Okay, let me just stop there for a second. Okay, the facts in the record that Justice Holmes recited. Did they mention any of the facts I just told you 5 minutes ago? Okay. This was a procedure that on its face looked totally fair, but it was not adversarial in any way. Even though Buck was given notice, she wasn't the sharpest knife in the drawer. I'm not saying that to be mean. She simply wasn't. Okay? She probably didn't understand what these trumped up charges were. Okay? Did she get a lawyer? Steve, did you get a lawyer? And where did this lawyer come from, Steve?
He was a member of the governing board of the institution.
Okay. So the lawyer appointed for Carrie Buck worked for the colony where she worked. Yeah.
He had also personally authorized her sterilization order.
Yeah. The lawyer who approved Carrie Buck's sterilization and worked for the colony was one in charge of defending her interests. Can you imagine? Can you imagine? Right? Again, they followed the process. The lottery, right? They drew the paper had the mark, they drew this and that. Nikolai, is there anything procedurally unfair? Did in any way, did the Virginia colony not follow the law, not follow the procedure set up by law? They followed it exactly, didn't they? So this is the difference between a procedural due process and a substantive due process. In every respect, there was a fair process. In every respect, right? The hospital presented the evidence. They gave notice of when this hearing was going to be held. They even gave a lawyer. Hell, look, there was evidence. There's evidence. Look at this awesome evidence. Look, I mean, bam. You need written evidence. They drew up a family tree. It's very pretty with these dotted dashed lines, right? Was that? Yeah, it's science and evidence. And even then, they could appeal to the court. They could appeal all the way to the Virginia Supreme Court of Appeals. So procedurally, every procedure was complied with to the T. But this case illustrates very poignantly, in my opinion, whether this was substantively fair, right? Even if you follow the procedures, was this complying with the substantive law? So Toshiba, how does Justice Holmes, Mr. Holmes, does he seem interested in questioning whether this law is substantively fair?
Yeah, he does.
What does he say?
He goes on to talk about that this is for the better of society.
Oh, yeah. You didn't answer my question correctly, but you actually did, right? So, yeah. So your answer is actually better than what I had in mind, right? So you would think that a judge sitting there would say, oh my God, this is awful, right? This is awful. But instead, Holmes, with his mustache and all, again, someone emailed, why are you not a Holmes fan? I think you emailed me this. Holmes with his mustache said, this is awesome, right? This is society trying to make society better. He sees no difference between a law limiting the number of hours a baker can work with a law that compels the sterilization of Carrie Buck. If this is what the democracy wants to do, have at it, guys. A quote I gave you last week, if my fellow man wants to go to hell, I will help him get there. And he took that seriously. He viewed no role for the court to intervene to second guess them, right? Caleb, did he give any skepticism for the facts that were presented by this case? Was he all skeptical that this woman indeed warranted sterilization?
I don't think so, no. I think he's pretty satisfied with it.
Yeah, he basically recites the findings of the board without any skepticism. He basically says, yeah, this is what they found. You know, who am I to second guess that, right? Even though the stuff I'm telling you was known, right? I'm not giving you some made up stuff. This entire business of feeble-minded. Why was she feeble-minded? Raped. She was raped. Why was her mom feeble-minded? She had syphilis. Why was the daughter feeble-minded? Because the stupid coin thing, right? She didn't react to the coin. You would think a court may say, wait a minute, but social science told him that this was correct. The elites, the scientists, the experts, the university professors getting medals from Hitler, right? They knew what was best. I'm not exaggerating. This is why there's a diploma from the Third Reich University in 1936 at the dawn of World War II to this guy, an honorary degree. Can you imagine? Holmes though also makes it. Go ahead, yeah.
I mean, suppose this wasn't like she was raped and she wasn't technically mentally retarded. It is a mentally retarded person, and I don't know. What would your view be that they can have?
Are you asking me if a person is mentally handicapped to be sterilized? Is that what you're asking me? No. Next question. I mean, what's
I like the
probably double advocate? Okay, I'll go there next. Okay, that was actually my next point. Okay, so Holmes moves on to a point that's actually is stronger, right? After he moves, look, devil's advocate, right? Yeah, devil's advocate. So Holmes moves on to a different point. He says, listen, Kevin, we have the draft, right? And Kevin, we call people to go to the draft, and we just had a bloody war. Holmes himself fought in the Civil War, which is kind of surreal to think about. He was severely wounded. I think he injured his leg or something in the Civil War. If the country, Kevin, can call on people to die in service of their country, does that greater power include the power to maybe temporarily wound someone, also for the greater good of the country? This is Holmes' actual legal argument, which comes fairly later in the opinion. In other words, there's a greater power saying we can kill you for your service of country, including the lesser power saying we'll just wound you or maim you for service of country.
He states that the principle that sustains the compulsory vaccination is broad enough to cover cutting off working things, which is
Yeah, so there's a couple cases. The next one he mentioned, one called Jacobson versus Massachusetts. This was a case decided actually, I think the day before, or the week before. It was decided right before. One thing to note, this is not anti-vaxxer stuff, okay? So today, people who don't have vaccinated children are insane. They're crazy. We don't listen to them. But at the turn of the century, vaccinations were awfully dangerous. A vaccination gives you a weakened form of the virus. And in many cases, you would die from the virus. This is not people worried about like mercury poisoning and autism. This was actually a legitimate fear. So Massachusetts passed a compulsory vaccination law. I think it was about smallpox. I can't remember. I think it was smallpox. And a guy objected. He said, I don't want to be vaccinated, right? Okay, and then Justice, I think it was Justice Harlan actually wrote the majority opinion, and Harlan effectively said, if we have an outbreak, a contagious outbreak, and one person's not vaccinated, the entire city can get the smallpox outbreak, and all these people will die. So we can force someone to undergo this vaccination for the greater good. So Brian, you're up next. Does the power to force someone to be vaccinated justify the power to force someone to have their fallopian tube severed, or their, for men vasectomy? It went both ways.
I think that they're both, it's better for the government, I guess.
Oh yeah, the state loves it. Yeah.
Well, I mean, it's not that strain on the government, like with in the case of vaccinations, soldiers don't get this, they become sick and the government pays for it, right? In the case of the mentally retarded person, they can't take care of themselves, how are they going to take care of a kid? The government does. So I think that's what it's.
So how was reading this case for you?
I'm glad it was back then. I mean, I have explanations for them. I think every life is important, and you spend enough time with the kids, you see what success and the meaning of life really is. The government can worry about money, but
so
you can't take away people's personal.
So let's focus on the question I just asked Brian a minute ago, right? Do you think a law requiring vaccination, I mean, your school, which requires vaccination to be admitted, how would you compare a law requiring vaccination to a law telling sterilization?
I don't think they compare, because I think the law for vaccination, even though there's a debate, is literally for the greater good. Yes, it's about the state not having to pay for it, but you can save lives with vaccination. People don't get sick, people survive. Sterilizing people and taking away their right to procreate, you're making a judgment on them and saying you're not good enough for this world, you're not good enough to procreate. And we know, like half the kids in my life skills classroom, their parents are totally normal, upstanding citizens. You don't know why you get a kid who's disabled. Sometimes sometimes the parents do drugs and it's obvious. But that happened to me maybe 3 times in 9 years. Oh my gosh, this is a drug baby. Majority of the time.
Do you know, and actually, I don't know the answer to this question if you know, how many of the students in your classroom grow up to have families? Or not families, at least become pregnant and have children.
A lot of the girls. But see, like in that situation, if the parents are in charge, and I don't have a problem with sterilizing the kid. If the parent's going to be in charge of the kid for the rest of their life, and they're conservative and they make that decision because things go out of their control, that's different than the state coming in and saying, you're not good enough. But a parent is going to be responsible for a 40-year-old who's like the mind of a 3-year-old. In my mind, that's more like the vaccination. You're doing the kid a favor, or the future 40-year-old.
So Elizabeth in the back.
Yeah, in this type of cases, why do you need vaccination? How do you know what flexibility and the aspects?
Vaccination or sterilization?
I'm sorry, sterilization, they only have in mind the.
Well, it doesn't take a mensa person to have sex.
No, but
I mean,
that. What told me about this case is that they promote these types of laws, people who actually are in homes or hospitals or wards, they can get sexually.
That's the problem.
there's rape, yes, and this is why Carrie Buck was raped by her uncle. I mean, this is molestation, right?
Having the evidence of those, would you take that away? The hospital.
Oh, you're saying pregnancy is the only evidence of rape?
Yeah.
It's not the only, I mean, especially if children are 10
When
times,
it's-
6 or 10 times more.
This way, not that way.
It's really-
No, I appreciate the dialogue. I appreciate we have subject matter experts in this area, but Darryl, your hand was up?
Well, no negation is the assumption that if someone who's mentally impaired, their children will be also.
Which is not the case.
But with the vaccinations, it's an immediate result that says the greater good is protected. It's just not strong on like
Yeah.
every
Caleb.
policy, but
And I mean, I could be wrong here, but I think there's a fairly dramatic jump from compulsory vaccination, especially in the 1920s and 1930s, where there was some risk of death from vaccination. But there's a fairly big jump, I think, from saying that compulsory vaccination is broad enough to cover such a life-altering procedure such as sterilization. I mean, that has a much greater impact. You're not feeling unwell for 3 or 4 days. Your life is drastically changed from that point, and it is unchanging after. So that's a big difference in terms of the impact of individual liberty.
So hand somewhere here. Yeah.
Along that line, the draft, the vaccinations, these are things that have immediate, profound impacts that you can put a finger on and direct. With this Darwinism or whatever you want to say, this isn't an ideology. You can't. If anything, you're looking at 100 to 150 year impact.
So actually, let me push back. I'll play devil's advocate for a bit, right? We talk in terms of compelling state interest, right? And I think we'd all agree that preventing a smallpox outbreak in a city, that's pretty damn compelling, because basically the entire town get wiped out. Service in the army, that's pretty compelling. If we don't, we'll be invaded and our nation will be gone, right? But think of what social science said in the 1920s. Eugenics is the future, right? If this is not clear from Holmes' opinion, he views this as a compelling interest of the highest order. So maybe today it's easier for us to say, oh yeah, you need vaccinations, but Holmes was saying the principle that sustains compulsory vaccinations broad enough to cover this. He thought our world was doomed. The Malthusians, there always Malthusians, right? I think the world run out of food. People always around.
How many years, though? I mean, you're looking at, even with him, it was 150 years.
Yeah. Kathy?
They say 2 years after this that they were endorsing sterilization for schizophrenia and depression. They thought that's like 10% of Americans.
Oh, today perhaps.
Yeah, and that's what they, why take away health if that was the case.
That was part of the plan. Yeah, right.
Vaccinations too. As a government, you have to protect your citizens and make sure that you can improve their lives. Vaccination is a form of that. It protects them from disease and so on. While this cuts off a right that you were born with.
Oh no, but I'm going to stop you right there for a second. Holmes said this protects society because society has to pay for these people. The Holmes believed that by stopping these people from reproducing, you will no longer have drags in the social welfare net. What?
He's playing God by deciding who gets to reproduce.
Well, that's what the state did. He's just saying idly by. If my friends want to go to hell, let them go. Help them get there. Janine.
So, let me preface this by saying when I read this case, I was disgusted.
That's about right. Yeah.
But then, and even you have said you have to sometimes put on the lenses and go back to 1925. And so when I do that, I think about the rape that she went through, and I think about it was almost in the 70s or 80s, 1970, 1980, before it took that rape wasn't the woman's fault. And
It's because she was promiscuous. That's what they deemed. Yeah.
So they deemed her because it was her fault that she was raped.
Mm-hmm.
So we have to stop that. And if you look at even today with the cost of a 40-year-old individual who has the mind of a 3-year-old, who essentially the state becomes their guardian. That's $60,000 to $80,000 a year of taxpayers' money of our deficit budget of that goes through that. So if you're homes and you know it's costing us this much money to have these individuals in this home, and it's best if we stop this now.
That's exactly right.
Putting those lenses and those glasses on, I'm like, I'm really glad I didn't live in
Yeah, I am
But
too.
when I look at it that way.
It's a very mature answer. I mean,
This opinion makes more sense to me.
yeah, and that's why I show you all this propaganda about eugenics. This wasn't sort of fringe theory. It wasn't like a white supremacist, This was the elite, well-respected sociology president of Harvard University espousing this. In fact, as disgusted as we are by eugenics today, in 1925, they will be disgusted by how we view race. We have black and white kids in this classroom, learning together. Imagine that, right? We have people who are mentally handicapped having children. And Janine, your point's well taken. As revolting as we think of them, they would view us in the same way. And it's helpful sometimes to put the glasses on. And so I appreciate actually Brian putting the devil's advocate on. It's actually worthwhile. Although I'll go back to attacking Holmes. He actually agreed with this stuff wholeheartedly, right? He wasn't just deferring. He bought in. Yeah. Michelle.
Well, I was gonna say, all it took was a madman, Hitler, and just they move it from, again, bipolar, schizophrenic, promiscuous women to being a race, being Jewish. And it was only then people saw that, okay, this is what happens when eugenics goes off the chart.
It wasn't then, because it continued to the 1950s and 60s.
Well, I'm just saying.
It's continued.
I
It didn't stop.
I think it still exists today. It does. But I'm just saying people aren't buying it.
They maybe disagree with
to the
Hitler's
degree they did
fascism,
back
but they
in the
didn't disagree with his eugenics. All right, and Daryl will finish it up.
Well, it just seems like when you think about eugenics, it should have been against vaccinations too, because let the smallpox kill those who can't.
Yeah, but if
live
the smallpox outbreak comes to Beacon Hill, Massachusetts, that's a problem. When if the staff and the servants in the home, if they get smallpox, we can't have that.
But if all the people sit up to it die, well, hey.
Yeah, but what?
But
But if his servant lives in the poor neighborhood and comes to deliver his newspaper, they can't have that.
What I'm just saying, you take it out to the nth degree with them. Survival of the fittest.
Well, vaccines weren't good enough that something called herd mentality, where if a certain percentage of society has vaccinations, you stop the outbreak. But if that drops below a certain level, you can't stop an outbreak, even if you have it. Slightly unrelated, but during the Obamacare arguments, Justice Breyer asked one of the lawyers for the challengers, could the federal government pass a mandatory vaccination law under their commerce powers? Would that be compelling interest under the necessary and proper? He basically said no. So that was an interesting deviation. All right. Any questions on Buck? Any other things we didn't mention? So Holmes basically says the statute does all that it can. It's within the lines. That's all we need to do. There's effectively no judicial scrutiny. He does not in any way second guess it. Justice Butler, who was actually one of the so-called four horsemen, the conservatives, dissented with that opinion. The book didn't omit it. There was no opinion. This is a fairly common practice at the time where you actually have a dissent with no opinion. It wasn't that they were lazy, but they just had a lot more stuff to do. And if it was only one justice, they didn't bother with a dissent. That's why Harlan's solo dissents were so significant. He actually wrote out full, lengthy dissents. Yeah, Aaron.
One point we didn't mention, one thing we didn't mention is that this case is still on the books.
Oh,
It's never been overturned.
yeah. This case has never been overturned. And does anyone know the case where it was favorably cited? Roe v. Wade. So Roe v. Wade favorably cites Buck v. Bell for the proposition that the state has an interest in regulating people's health. You'll be shocked when you read Roe. You thought Brown was shocking. Roe's even more shocking what it doesn't say. I think they edited out your book, which breaks my heart. But Roe actually favorably cites Buck v. Bell, say that the state has an interest in ensuring basically women's health. It's not about privacy. It's about the state's interest in preserving the doctor-patient privilege. Yeah.
Just one quick other side look around at modern and that's what's going to be interesting to me is how the law is going to handle genetic manipulation moving forward. We have so much science now that can detect unwanted genetics.
Well, I'll give you an example. This actually happened. So Ohio they passed a bill, but I think they're going to pass it, that prohibited an abortion in case of Down syndrome. Am I getting that right? I think that's right. because that there are now means of testing if a child has Downs in utero. Yeah, we'll get to that later, but food for thought. I don't know if that law actually passed or was introduced, and I can't remember, but I didn't prepare this, but I know this came up fairly recently. Some jurisdictions have considered passing laws saying you can't have an abortion if based on gender of the child, if you just don't want a boy, you want a girl, whatever. Because in China, for example, where there's a serious premium having boys, it's very common to simply have an abortion for all girls. And in fact, there's a serious shortage of girls. It's going to have a population problem as well. That's why Chinese men have very difficulty finding spouses. Okay. Any other questions on Buck? Nice. Go from, sterilization to penumbras, right? Okay, so let's move on to Griswold versus Connecticut. Yeah, that's why I admit I can't do that case neutrally. It's too hard. Here we go. I'm sorry? You wouldn't know it sometimes. Lots of other cases, like I can do Dred Scott neutrally. I can actually, that one, but this case I can't, oddly enough. I can do Korematsu, that, I can get that, but this one, no.
Sorry, out of curiosity, how does this not disrupt? But this one does so badly, and Obamacare does so badly.
Well, Obamacare is personal. Just make sure.
Actually,
So,
if we count, I think you mentioned it every class period, but
yeah, no, I mean, so what's interesting?
Sounds the way it works. But like,
Yeah, no, I mean, so I mean, Dred Scott at heart was about diversity jurisdiction, and that part of the decision. Right, the other stuff. Yeah. 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 Well, Korematsu also, there was an argument to be made that under national security that may have been necessary in certain cases, right? The issue is like this. Under no circumstances could I envision a law where sterilization is actually necessary for some state interest. In Korematsu, I could imagine circumstances where detention may be necessary. Not that I think it's right, but I can conceive of it, right? With Buck, I can't conceive of any circumstance where that'd be an appropriate action. No. Well, the part of Tawny's opinion about diversity jurisdiction was premised, in fact, there was an argument that people at the time did not think the Africans were citizens, right? It was effectively, as an interpretation of the original meaning of the Constitution, it wasn't entirely crazy. You see what I'm saying?
No. I mean, I see what you're trying to say.
In other words,
like,
as in...
It's sort of like when you said you have to add the yes. I mean, we go back to the intent.
Right.
For me to wrap my head around.
Right. So as the Constitution was understood, right, as the practice was in 1787, it's not crazy to think that Africans were not considered full people. Not that I think it's right or wrong. So as practice was at the time of the founding, it would not be crazy to say that Africans were not viewed as full people. A lot of the 3/5 clause, a lot of the fugitive slave clause. So as repulsive as what Tawny was saying, his constitutional argument was in the ballpark of what could have been understood at the time. See what I'm saying? It's not that what he's saying is necessarily socially acceptable, but it wasn't an insane argument. Here we have a case where the Constitution says you can't deprive someone of a liberty interest without due process of law. I can't think of any sense in which this person is afforded due process. I can't think of any sense where you can say that a removal of an organ is not a liberty interest, perhaps even a property interest, right? I can't think of any instance where this case was correctly decided, right? It's not even, there's no attempt for the judge to act like a judge. He simply just accepted the supremacist understanding, the eugenic understanding, and pieced out. That's why, it's not that I like those other decisions. I think they're quite egregious and wrong, but this case represents a callousness to even attempt to make a legal argument. There's nothing there. Yeah.
I have a
truthfully is, I feel the same way too, because I kind of admire his willingness to just stay out of it at all costs. And if he stays with that, that's fine, so be it. But when you use the words in the manner he does and the attitude behind
That's-
it,
yeah.
sap the strength, or, there's a negative, he's got a negative viewpoint of these people. And that's what I had to know. You want to stay out of everything. That's admirable if you have your viewpoints and that's what you believe and you stay with it, you're consistent with it. But when you look down on people, that's the problem.
Yeah. Yeah.
So, I mean, when you think about these guys from the perspective of the eugenics, and that these were the people who established the country, right? And they were representing, I guess what it makes me, it comes back to our founding fathers. Did they really only create a nation for those that look like them? And is our nation kind of just, we are fortunate accident that we ended up in the place that we ended up, right?
Well, I think you have to include the frame of the 14th Amendment with that as well. It's not just the Constitution of 1787. So the original 1787 one, to the point of Dred Scott, the argument wasn't insane. But after the 14th Amendment, the argument is no longer tenable. All right, other questions? Let's do Griswold. So again, as way of background, by the time we get to 1964, the idea of substantive due process was buried, right? The idea of Lochnerism with Myers and Pierce was seen as an abomination. And if you had been sitting in a law school classroom in 1964 at Harvard or at Yale, your professor would have said, we do not want judges deciding what liberty interests are under the 14th Amendment. We do not want judges second-guessing the reasonableness of the laws. We do not want courts getting in the way of social progress. And that would have been the gospel. But the lurking issue that everyone knew was coming was abortion. And even to this day, it remains one of the most divisive issues in our country, 35 years after Roe. And as often happens, the democratic process was not moving quickly enough for certain advocates. One of the interesting aspects, which people don't fully appreciate, is states were actually slowly moving to legalize various abortion procedures. The single greatest thing that retarded that, poor choice of words, but that slowed that, was Roe, because it created a serious backlash among evangelicals. We think today the evangelical community and the Republican Party being committed to opposing abortion, these issues weren't even on the radar in the 1960s and 70s. They really weren't. But the reaction to Roe created such a blowback that it made it a galvanized issue to this day. And indeed, this was some of the fear that existed concerning gay marriage, that would have a similar impact, although we'll get to that in a couple of weeks. So the advocates who wanted to identify a right to abortion in the Constitution realized they had to go at this somewhat incrementally. And one of the first chips to knock off concerned contraception, birth control, right? And this isn't just a pill. This involves condoms, diaphragms, foam, whatever you want, top to bottom, right? I guess also poor choice of words. That was not deliberate. God. These laws were not enforced. So in the same sense that in Lawrence v. Texas, which we'll study, Texas had a law prohibiting criminal sodomy. These laws were never enforced for a very simple reason. Generally, police are not in people's bedrooms to witness sodomy. Generally, police do not go into a person's bedroom to witness them using contraception. It doesn't happen. So it becomes very difficult to actually police this. In New Haven, Connecticut, which is where Yale University is, it's a city. Estelle Griswold was the director of the Planned Parenthood Center of New Haven. Here's a picture of her standing in front of it. And Planned Parenthood, Connecticut had on the books a law that had been the law forever, which prohibited married couples from using contraceptives. And if a married person used a form of contraceptive, they will be fined or potentially go to jail. Now, where's after? Okay, so Andrew, were any married couples in this case arrested for using birth control?
No.
Who was arrested in this case?
The doctor who gave him birth control
And
and the director of the facility.
okay, so pause for a second, right? The statute said anyone who uses it violates the law, but also anyone who assists, abets, counsels, causes, or commands another to use these products would also be offended. So this wasn't about the police arresting couples or married people using it. They actually went after, this is their booking photo, right? They went after the doctor who prescribed it and the director of the Planned Parenthood facility. Now, they wanted to get arrested, okay? They wanted to get arrested because they wanted to challenge this in court. There was no question about this. They wanted this in court. Okay. Do they need to challenge this in court? Anyone know the answer I'm thinking of? Was a court challenge here really necessary? There's a footnote I'm talking about in the case. Yeah. No, in this case, wrong footnote.
Oh.
Anybody see what I'm talking about? See if we can figure out what's saying. Did they actually need to bring this one to court?
It was already, what in the legislature was already going to take care of it. They want to speed along the process.
Okay, so here's the important point. The Connecticut legislature had already moved to repeal it. So I think one house had repealed it. This is what the dissent calls an uncommonly silly law. It's a silly law. How can you enforce this? And they basically wanted to get arrested. They openly flouted it for the intent of getting arrested. But they needed this not to be repealed. They wanted a Supreme Court decision saying the right to whatever. We'll get to that right in a minute. But this is what we call, cause litigation, right? They wanted a Supreme Court ruling on this front to pave the way for abortion. This Planned Parenthood wasn't doing abortion; they were handing out pills, right? We're not there yet. That would come. Yeah, I don't think they were there. If they were, that wasn't legal at the time. Okay. So the first issue, again, is something similar. Clint, did this doctor have the right to raise? I'm sorry. If it was a married couple, right, who actually was arrested, what is the constitutional liberty interest that's being infringed? If it was actually a married couple being arrested,
That it was their right of privacy.
yeah, their marital privacy in the bedroom, right? Do doctors have a right of privacy to dispense medicine?
What's the doctor-patient confidentiality?
Okay, this is the important point. In the same sense that a Society of Sisters, a school, raised the constitutional rights of their students, same sense, here the doctors are raising the constitutional rights of their patients. The doctors are raising the rights of their patients. It's very similar to the Society of Sisters case we did before. So no, this wasn't the doctor. Doctors can regulate it up to the wazoo. They have to be licensed, this and that. They can prescribe this, they can't prescribe that, fine. But the doctor here was actually raising the rights of the patient. Okay? So the opinion opens up. And they say, some people suggest that Lochner should be our guide. Taylor, do they want to follow that evil thing with the bakery and the dust and the... By the way, totally randomly, but did anyone watch the C-SPAN special on Lochner? Did you like it? Yeah, my reaction too. It was okay. Yeah, don't bother. But totally randomly, I tweeted about it, right? And Joseph Lochner's great-great-grandson emailed me. And send me this long family tree. I got to blog about it later. I have to give him a call sometime. But the random things that Twitter does. So Taylor, let me ask the question again. Did they want to follow this evil, odious opinion of Lochner?
No.
What did they say? It's right at the outset.
I think they thought they
didn't want to follow the substantive due process cases, that they kind of were changing, like shifting it
Mhm.
and turning it into like a First Amendment.
Okay, let's unpack this slowly. Okay, so first they said, we're going to do what we did in West Coast Hotel v. Parish. That was the switch in time that saved 9. That was the Owen Roberts decision where he changed his vote to basically uphold the Washington minimum wage law. And the court says we do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems or social conditions. Okay, that's one sentence. The next sentence they say, this law, however, operates directly on an intimate relation of husband and wife and the physician's role in one aspect of that relation. Taylor, how do those two sentences not mean the same thing? What's the difference between sitting as a super legislature over social conditions versus saying that this law operates on the relations of husband and wife? What's the difference? How is that not a social condition or a sort of affair?
I mean, I think it is because they're limiting a married couple's right to
But is that not a social condition? Is that not like Myers v. Nebraska or Pierce, where they said that you can decide how our children are educated? What's the difference?
Does it have to do with the right to privacy?
Versus privacy.
Well, because like you were saying, the government's not going to know if the married couple is using contraceptives. But
The law prohibited teaching your children of any other language. If you do that in your private home, you can be criminalized for that. Richard, what do you think? How do you distinguish between sort of substantive due process cases in the Lochner line with what the court does here?
Well, I was thinking about how it wasn't just the married people, it wasn't actually in this case at all the married people that were being convicted of something, it was people helping them as accessories.
Mm-hmm.
So it's going outside of their bedroom.
Mm.
People that are prescribing it can get into criminal trouble, yeah. And it's not just within your bedroom.
But if it's outside the bedroom, doesn't that make the argument different? That's not about privacy, right? In this case, they were actually punishing a doctor engaged in a regulated profession.
I'm thinking it's the same thing, they just don't want to mention law. They don't want to be associated, so they're justifying it through alternative.
And what do you think? How do they distinguish Lochner from this decision? The majority by Justice Douglas.
I think they base it on Pierce versus Society of Sisters, not Lochner.
Ah, so that's what they say, right? They're saying, look, we're not doing Lochner here, but we like Vyre, Nebraska, and we like Pierce v. Society of Sisters. But Tam, what was the basis for Meyer and Pierce? We did these cases earlier today. What clause of the Constitution were they relying on there to get to Meyer and Pierce?
14th Amendment,
Which provision?
the due process.
Yeah. So we can argue at the margins over whether Griswold, in fact, followed Lochner or not. It doesn't really matter because they said they weren't, and that's good enough for most law professors to say, well, they're doing something different. Well, they weren't. The same sort of judicial scrutiny that applied to Myers and Pierce and Lochner was extended in Griswold. These were not First Amendment cases. They try and suggest that Myers and Pierce read the First Amendment. They weren't, because we discussed the First Amendment hadn't even been incorporated to the states yet. These were due process cases in every sense of the word. Okay. By the way, pay very close attention to Griswold, where it discusses the rights of married couples. If you're reading for next class in a case called Eisenstadt v. Baird, where it involves birth control for non-married couples, look how quickly you get rid of the marriage distinction. This is just a placeholder. They don't actually mean this marital bedroom. That's just rubbish. right? None of that matters. It's just a placeholder. You'll see how quickly in the next case they get rid of that. Brendan just tosses it away like it's nothing. Okay. So let's move on from Pierce and Myers. So Darryl, you're up next. How does the court go about fashioning this right of privacy, which Taylor mentioned a minute ago? I mean, I'm looking at the 14th Amendment here. I'm looking real close, right? I can scrutinize it.
There, you just don't see it, kind of.
It's there, but I don't see it. What do you mean?
It's suggested. It just, you gotta have it. It's just, you got to for us to make this law good.
God bless the Warren Court that can teach astronomy and ConLaw. Okay, so do you want to actually look up what a penumbra is? Okay, right. So astronomy. Okay, so science. IFL science, right? So you have the sun, you have the earth. The sun casts light, and this part where there's light is day, and the other side of the earth where there's no sun, there's night, right? Okay. When the sun shines on the earth blocks the light, and it casts a shadow on the moon. And this is the part of the moon that you can see, the part that's not shadowed. That's called the umbra, okay? There's this kind of hazy aftermath of the shadow called the penumbra, that there's certain shards of light that come from here into this region where it's kind of dark, kind of light, almost like a zone of twilight. You want to use another astronomical symbol, right? So Justice Douglas, whose opinion in this case is largely ridiculed because it makes no sense, but we'll try to do it charitably. Justice Douglas says that just because you have a right in the Constitution, that right has penumbras to it. Okay, that each provision of the Bill of Rights has this kind of shadowy region around it, which affords additional protections beyond that which is there. So he looks at something called the right of association, right? The First Amendment has no freedom of association. It's not there. But the court effectively inferred it from the rights of free speech and free assembly. We have the Third Amendment, the right of quartering troops. Well, that doesn't really speak of any sort of right of privacy, but if you can keep troops out of your home, well, then that's privacy. He looks at the Fourth Amendment, that you can be secure in your person's papers and effects. Well, that's about government keeping out of your stuff. Well, that's privacy. He looks at the Fifth Amendment, the right against self-incrimination. You have a zone of privacy against a government forcing you to say something. Privacy. He skips the Second Amendment, curiously, but we'll forgive him for that. He has many sins, Justice Douglas. One of the funny aspects of Justice Douglas is he was married like 4 times. He married several secretaries, and as secretary would get too old, he would marry the new secretary. It's went on for a while. He was on the court for nearly 30 years, and he was severely disliked. He was a jerk, and he actually considered leaving the Supreme Court to run for president, but he couldn't because he was divorced. At the time, divorced, they could not run for president. Justice Douglas is also insane. The guy was crazy. He single-handedly issued an order stopping a bombing run in Cambodia. This is nuts. So he would always go in the summer to his cabin out in the woods of Washington, and somehow these attorneys, these anti-war attorneys, found him, and they gave him an order asking him to issue an injunction to stop a bombing run in Cambodia, and he signed it himself without referring to the rest of the court. And he basically said, because I can't get to the rest of the court in time, I'm going to do this myself, right? Within like a couple hours, the court found out. They all reversed him and said, this guy's insane, ignore him. The bombing run proceeded. So he was crazy, and his opinion is farcical. But this is what passed for constitutional law in the 1960s. So effectively, he fashions this right of privacy, not from any explicit amendment in the Constitution, but from these emanations from the penumbras of the Bill of Rights. This idea that the Bill of Rights speaks to some sort of greater purpose than what's actually there. So rather than looking to the Due Process Clause of the 14th Amendment, and this is actually the move he makes distinguished from Lochner, which is not very good, rather than just flat out saying that one of the liberty interests protected by the 14th Amendment is privacy, he does not say that. He says, we get it from all these other amendments that are very hazy, right? Is there much of a difference between recognizing the right of privacy straight up from the 14th Amendment or grasping at these shadows from the Bill of Rights. What's the difference between his methodology here? Yeah, so tell me what's the difference? What? Oh, actually, maybe there's not a difference. What do you think?
I mean, the 14th Amendment speaks to, this notion of we don't have due process, but then taking from these other amendments that have a specific focus, like the right to bear arms or the right to freedom of speech. So I don't really understand the question.
Which is a better home for right of privacy, the 14th Amendment or the penumbras?
I would say the 14th Amendment.
Why would you say that?
But I'm thinking about
So speak out loud, right? Is there a risk involved with using one or the other in terms of judicial philosophy? What's the risk there? Do either provision of the Constitution say a damn thing about privacy? Okay, right? Neither the 14th Amendment's Liberty Clause nor the penumbras, Lord help me, of the emanations of the Bill of Rights say a thing about privacy. So whether the court reaches this right of privacy in the 14th Amendment, which they ultimately do in Roe, or they do this silly penumbras thing, it reaches the same result. And it frankly makes no difference how they get there. Nor do I think it makes a difference to the court itself. And this is why substantive due process is so controversial, because effectively courts can start fashioning rights with these arbitrary ad hoc methodologies, whether they look to the 14th Amendment, the penumbras, the 9th Amendment, which we'll get into in a few minutes. It doesn't really matter. Mark, are you raising your hand?
Yeah, I thought we learned at some point in the Supreme Court, somebody said that the Bill of Rights was built into the word liberty. Right? So liberty means essentially that.
Yes, so under the doctrine, okay, yeah, so you're talking about the incorporation doctrine, right? The incorporation doctrine effectively said that the first 8 amendments of the Constitution are considered so important that they're incorporated to the phrase liberty. But this isn't incorporating the amendments themselves. It's incorporating the numbers from them, right? It's not, if the state passed a law saying there's no free speech, that's an easy one, okay, it violates free speech. But they passed a law saying that you can't have birth control, well, that's a little bit more, it's a little more hazy, let me use the phrase.
The incorporation, say, clause or
It's a doctrine. It's effectively, there was a series of cases where the court said that the provisions of the Bill of Rights apply through the Due Process Clause.
But it's not in totality, meaning liberty doesn't just equal the first 8 amendments.
No, and what makes this complicated, we'll do this in a couple weeks when we do the First Amendment. What makes this more complicated is the court did it one right at a time. They said, okay, free speech incorporated, free exercise incorporated, a jury trial incorporated. And what's interesting is the test they used to incorporate was whether a right was considered fundamental, right? Basically, is this right so important? And virtually every single right was deemed so important. There's actually one exception of whether in a criminal trial, do you need a unanimous jury? And for reasons that are too complicated to explain, the Supreme Court split on that issue. So you can actually be convicted in some states with a non-unanimous criminal jury. But virtually every other right has been incorporated in full.
That was after this decision.
During the 1940s, 50s, and 60s, all these rights were incorporated one at a time. It's called jot for jot, one right at a time. But even then, those are still rights that are enumerated. These aren't these hazy, penumbra, fuzzy, whatever.
I guess the point was, he wants to put this within liberty. He would have to then be just by default. Or by default, he says that it's the right to privacy is part of the first, third, and fifth amendment. By default, it would be liberty at that point.
But that'd be Lochner. If you notice, he's staying away from the word liberty because he doesn't want to do Lochner. They move off that in a couple years, but at least in Griswold, he does not want to go through the Liberty Clause. Daryl's your hand up?
Yeah, he was. It seems like he was trying to give gravitas to it by citing all these different, like, oh my gosh, they're
I never noticed that before, right?
And he wanted to, all these things. It has to be this because look at all these rights that kind of, sort of, maybe fit. Just list enough, throw enough stuff on the wall and see what sticks.
Yeah, I mean, the other issue, this was the 1960s, and they started to really get creative in the Warren Court here. And this was like them trying to do new stuff. We'll get to Ninth Amendment in a minute, but they're trying stuff out, feeling out, you know. Yeah, Michelle?
This is just helping me follow the doctrine of what we're doing.
Oh boy, there's no doctrine here, but
well, there is to Lochner, I think. So the question is, when did Lochner of liberty, of our economic liberty, go from being a fundamental to a non-fundamental? What case
so the
did
phrase fundamental didn't come till much later.
I know that, but in a sense,
But
they were
West
making
Coast Hotel
fundamental.
v. Paris, switch in time, that rejected that economic
So
liberty
it
was
kind of
special.
shifted it
And
to-
really, the answer is footnote 4 of Caroline Products. Footnote 4 rejected these sorts of economic rights.
Okay, so that's where we came up. And
Yeah.
then my second question is, at this point, the progressive movement would have sided with obviously Planned Parenthood, right? So here it was flipping its thought about second guessing what
Yeah.
the legislative was saying.
Yeah.
So it's flipping its
Yep.
thoughts. Okay.
That's a common trend. Wherever progressives go, that's where the law often goes. We'll do the first one later, and this is a point that I'll focus on at some length. But if you look at the free speech cases in the 1970s, they were always basically these social outs. They were the student protesting at school. There were people wearing a fuck the draft jacket in a courthouse. People were burning their draft cards. So free speech trended towards a very robust conception. Today, those prevailing in free speech are people like Citizens United, Sean McCutcheon, and people donating lots of money to candidates. And free speech, unsurprisingly, is drifting the other way. So free speech often is in the direction where progressive thought is. And when free speech is no longer consistent with progressive thought, with trigger warnings and speech codes, free speech falters. So this will be a serious trend that we'll see in First Amendment law. So the actual opinion itself, once you get past these penumbras, is very, there's not much there. He basically says, this is a relationship in the zone of privacy created by several constitutional guarantees. The law prohibits the contraceptives. This law cannot stand. Okay? There's really no analysis. Basically, once you're in the zone of privacy, this law cannot stand. What does that mean for anything else? Who the heck knows? But there really isn't much there. And at the end, I have to just vomit because of Justice Douglas's personal history. He speaks to the sanctity of marriage. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or worse, hopefully enduring, and intimate to the degrees of being sacred. Is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, whatever the hell that means, like a bilateral contract, is an association for as noble a purpose as anyone involved in our prior decisions. Okay. Whatever, Douglas. I'm not being mean, but this decision among ConLaw professors like reviled as being like just awful reasoning. Similar to Roe, there was actually a book written about 10 years ago called What Roe v. Wade Should Have Said. And when you read Roe, keep in mind how it could have been a much stronger opinion. It's a very weak opinion. You'll see what I mean. I'm not to take a position on abortion, but actually the reasoning is just, it's not good. And a bunch of these law professors who agree with Roe wrote a book saying what the opinion should have said based on precedents that existed at the time. It's weak. All right, let's move on to Justice Goldberg for a moment. This is the opinion that most students don't get properly through no fault of yours, because Goldberg makes it somewhat misleading. So what does Justice Goldberg say, Marcelo? What's the thrust of his analysis?
Well, he talks about the right to marital privacy, not directly, but not explicitly, but by the Ninth.
Okay, so we haven't actually talked about the Ninth Amendment much. I think I mentioned it maybe in the first day of class. So let me give a little bit of a background. When the Constitution was being drafted, there was a significant debate about whether we needed a Bill of Rights. And there was a distinct fear that if we list certain rights, that implies that other rights are not protected. This is the canon of expressio unius that you study in contracts. If you include some stuff, that means you deliberately excluded other stuff. So the Ninth Amendment was viewed as a way of rejecting that canon of construction. It effectively says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. So at a minimum, what that means is just because we have these 8 amendments doesn't mean that there aren't other rights that are in existence. Now, the controversial part is, what are these rights retained by the people? Do these refer to natural rights, common law rights, rights that judges can find? I'm going to put that debate aside for the moment. But the important point to figure out first is, who did the first 10 amendments of the Constitution impact? The states or the federal government? The federal government. Was the Connecticut law a federal law or a state law? A state law. Under no circumstances could the 9th Amendment prohibit the states. This specifically referred to the federal government. So Justice Goldberg cannot come out and say, ooh, the 9th Amendment means this law is unconstitutional. He suggests that, but he can't say it because he knows well that the 9th Amendment only applies to the federal government. So he too cannot rely on the 14th Amendment's due process clause because of Lochner. So he tries to say, okay, this penumbra business is silly. Let's try the 9th Amendment. Again, Darrell said, let's throw everything and see what sticks. This is what they were trying to do. It's how can we create the groundswell for a constitutional right to abortion? And actually, I think they put in your book, they put a district court decision, the Roe v. Wade, Texas district court decision. Or maybe they don't, I read it. But it was based on the 9th Amendment. So you actually had district courts finding rights to abortion based on the 9th Amendment. So the Supreme Court was sending out signals like, all right, guys, we got this case coming up. Let's try different things, see what sticks. Okay? Goldberg does not say that the 9th Amendment controls the states. Okay? The better clause Goldberg should have looked at was our old favorite, the Privileges or Immunities Clause. And actually, Professor Jack Balkin at Yale wrote a pretty interesting article explaining how one of the privileges or immunities of citizenship was actually the right to abortion. He actually explains why abortion is consistent with privileges or immunities. And this does control the states, which is called Abortion in Original Meaning. Very interesting article, which you can read. Anyway, let's see. So yeah, Goldberg just kind of puts us out. One point that Goldberg raises, though, okay, we're going up here to Tim. Both majority and Goldberg, do they say that the state can still criminalize sodomy, adultery, fornication? Can those things still be criminalized?
Yes, it can. But he says that the intimacy of a husband and wife is necessary for it's an essential and fundamental accepted feature of the institution of marriage.
Right. So they're not saying the state has no power to regulate morality. And this is an issue that will come up when you do the gay marriage case, right? Does the state have an interest in regulating in a manner that conforms to a certain moral vision? And the majority and the concurring say absolutely, right? If the state wants to prohibit adultery, fornication, bigamy, they can. By the way, did you study towards the tort of alienation of affections? Only, I think North Carolina, maybe one other state has it. That's probably not constitutional because you're basically having a tort enforced in a state court based on private relation. I don't think that's constitutional after Lawrence, but this actually comes up once in a while. So the court says, listen, you can still regulate everything else, but marriage is so important. It's all about marriage. It's all about husband and wife. It's all about procreation, right? Now, there's actually here a little bit of ConLaw. It's buried very deeply. So Pamela, did this law apply to everyone or just married couples?
This one,
Yeah. Why do you think the state has an interest in particular in having married couples not use contraceptives? What do you think the state's interest was there? Promote procreation, right? So the tiny bit of ConLaw that was actually in here was that this in no way prevents them from having adultery, right? Because if they're having sex with someone who wasn't married, the other person can get the contraceptive. That this was very narrowly targeted at only infringing on the marital relationship. It didn't affect outside of marriage. So on those grounds, they said if the state actually has an interest in promoting procreation, they can do so by other means. All right. All right. Any other questions on Goldberg? We'll go to Harlan in a minute. By the way, this Harlan, this is Justice John Marshall Harlan II. So it was actually the grandson, yes, the grandson of John Marshall Harlan the first. Go figure. I like the first Harlan a lot better, but I'm partial to him. So, Joseph, what did Justice Harlan say? What was his approach? Okay, tell me what that. Yeah.
Incorporate the Bill of Rights into the 14th Amendment.
Good.
So states could, the first state was tailored for the federal government, not even incorporated. States.
Good. Joseph, did Harlan think we needed to look at penumbras in the Ninth Amendment? Did Harlan think we need to look to the Ninth Amendment or all these penumbras and other things? He concurred in notice he concurred in judgment only. That means he actually, while Goldberg concurred, meaning he accepted the majority's reasoning. Harlan concurred in judgment only. That means he agrees that the law is unconstitutional. He doesn't agree why. So Joseph, did Harlan accept the reasoning of the majority with the Ninth Amendment penumbras and also their jazz? Why not? What would be the sole basis for him to rule? Due process clause, yeah. He puts all of his weight on the 14th Amendment's due process clause. There was a case he issued earlier called Poe v. Ullman, where he basically said judges who decide under the due process clause whether some liberty interest is so important, whether it's, quote, implicit in the concept of ordered liberty. If it's implicit in the concept of ordered liberty, that is, you cannot have a free society without it, the state cannot violate it. He effectively opens up and says we need to be honest, right? We need to be honest. Whether we call this a Ninth Amendment, whether we call this penumbras, at bottom, courts are deciding what these rights are. We shouldn't delude ourselves. Instead, to decide what these rights are, we should look to teachings of history, the basic values that underlie our society, and appreciation for the roles of federalism and separation of powers. So again, he's saying, listen, let's cut the crap, right? Let's not talk about penumbras in the Ninth Amendment. We as judges should be able to decide what rights are really important, and if a state violates those rights, we should step in. You know, there's a note of candor there. He's being honest, right? He's like, let's not make up these silly words. Let's just say we're deciding for ourselves what these liberty interests are. But the problem there is because he's so honest, he's very vulnerable to criticism if he's just making stuff up. And I think you can view it either way. Mark? Ain't it? Yeah. They can't get away from Lochner. This is why there's this inherent tension for progressives. If you like Griswold and you like Roe, it's very hard to reject Lochner. The only difference is you like one set of rights and don't like the other. But that's a matter of personal preference. That's not a legal argument.
I wonder if the state was, I mean, the country as a whole wasn't a little more ready at this time to accept you based on the Supreme Court justices or not having the progressive in the Supreme Court. You don't hear the outrage over this result, which has all the same overview.
Well, this was only about married people. This wasn't that big of a deal. Roe, though, had a massive outrage, which we'll talk about next week. That case, and actually Justice Ginsburg has written about this at great length, she thought the court was wrong to rule on Roe 1972 or 73, that the people were not ready for the decision, which is an interesting thought, right? Should the court only rule when the people are ready to accept it, or is the court ruling because the people are ready to accept it? Is it a chicken and the egg problem? I don't know which way that cuts either. But the decision in Roe perhaps came too quickly.
So because this had a better outcome, they didn't care how you got there.
People didn't care about the birth control law. So, I mean, let's go into the dissents, right? I think Justice White or Justice Stewart calls this an uncommonly silly law. Right? Stewart, yeah. An uncommonly silly law. And if you remember that phrase, in Justice Thomas's dissent in Lawrence v. Texas, he quotes that. He says the Texas law is uncommonly silly. And were he a member of the Texas legislature, he would vote to repeal it. Okay? So the dissent says, look, these laws are silly and stupid, but there's no ground on which we as judges can invalidate them. So Justice Black was the original textualist. So Scalia is also viewed as a textualist, an originalist. Justice Black came first. Also, an interesting aspect, Justice Black, who I probably won't mention again, he was a former Klansman. And Roosevelt appointed him to the court, and shortly after he was confirmed, it came out that he was a member of the Ku Klux Klan. He was a senator from Alabama. He said, well, to be a senator from Alabama in the 1930s, you have to be a Klansman. And in fact, the day he took the bench, a member of the bar stood up and said, we'd like to move for his removal. And the court basically just ignored it. It's a funny story. But he actually made good, and over his career, he became a very strong advocate for civil rights and became a First Amendment absolutist. He would often say, Congress shall make no law abridging the freedom of speech. No law means no law. And he would vote to invalidate every single speech law. So there are all these obscenity cases, I think I mentioned this, where you'd have a movie and they have to decide this pornography is obscene. And they actually had a movie theater in the Supreme Court, and it would screen these pornos at the Supreme Court. And Black refused to watch them because he said all these things are free speech and they're protected. That was his MO. But he's a textualist. He says, listen, there's nothing at all in the Constitution about privacy. There's nothing at all about this. And we have no license to this, right? The Ninth Amendment's not relevant. And this is Lochner. We are merely assessing the wisdom of laws. And he has this footnote to Learned Hand, who I'm sure you studied. By the way, you know what Learned's real first name was? Learned Hand, you know what his real name was? Billings. Billings Learned Hand. Learned was his middle name. He went by Learned, even though his name was Billings. Take that for what it's worth. So he said this is no different than Lochner. The dissent by Justice Stewart makes a similar point. Merely looking at these penumbras is not constitutional law. Okay. Any questions on the dissent? Right. So we have this weird tension, right, where the most evil case in the world, which we're taught to revile, like Emmanuel Goldstein, 2 Minutes Hate, right, is Lochner and its progeny and Pierce and Myers. Yeah, those are the very cases that are resuscitated, rehabilitated to get to, which is the end game of Roe, which was building up for a number of years. And Griswold is a way station. So as you read the cases for next week, Eisenstadt v. Baird and Roe v. Wade, I want you to pay very close attention to how all the limitations in Griswold go away. So all this bit about married couples, that disappears, right? All this bit about intimate privacy between married couples, that goes away. All the stuff about penumbras, that goes away. Ninth Amendment, not even mentioned. And they kind of gravitate onto this right of privacy as a function of the 14th Amendment by itself. All right, any questions? All right, have a great night. Thank you.